circulated to the bar. It's dated 3rd April, just to sort of fine tune the manner in which things should be filed, etc. Just make it more easy.
Saw that yesterday. Henceforth, it would be possibly that may not be in sync with the present status. It would be
prospectively.
Yes.
Yes, Mr. Gill.
May it please the Lord. My Lord, I propose, my Lord, what fell from your lordships yesterday when your lordships were rising. My Lord, I wish to make my Lord, temper the submission which I made in answer to a query that fell from your lordships. My Lord, would your lordships kindly permit me to take your lordships to Bihar Distillery, 97-2 SCC 727, Volume 5A, PDF 91, Para 23.
Volume 5. $76, right?
Yes, my Lord. And it's at Para 23. Para 23 is at PDF 91. PDF 91. My Lord's got it?
Yes.
Your Ladyship has it. My Lord, paragraph 23. At PDF page 91.
Volume 5.
Can I proceed? We are of the respectful and considered opinion that the decision in synthetics did not deal with the aspects which are arising for consideration herein, and that it was mainly concerned with industrial alcohol, that is, denatured rectified spirit. While holding that rectified spirit as industrial alcohol, it recognizes at the same time that it can be utilized for obtaining country liquor by diluting it for manufacturing IMFLs. When the decision says that rectified spirit with 95% alcohol content is toxic, what it meant was that if taken as it is harmful and injurious to health. By saying toxic, it did not mean that it cannot be utilized for potable purposes, either by diluting it or by blending it with other items. The undeniable fact is that rectified spirit is both industrial alcohol as well as a liquor, which can be converted into country liquor just by adding water. My Lord, on this I have a submission. Therefore, my Lord, I would most humbly request your lordships to kindly flag this statement. It is also the basic substance from which IMFLs are made. Denatured rectified spirit, of course, is wholly and exclusively industrial alcohol. This basic factual premise, which is not and cannot be denied by anyone before us. But would your lordships also like to read the note which comes? I don't know how it came about, my Lord. The footnote.
Footnote, yes. In fact, yesterday when it was being read, I was going to tell the learned counsel that let's see the footnote.
Yes.
I saw the footnote. It's very interesting.
If rectified spirit is toxic and unfit for human consumption, why is it necessary to denature it? Ask the learned Additional Advocate General for the state of Uttar Pradesh. Denaturing is meant precisely for making what is meant for human consumption unfit for human consumption, he says. Raises certain aspects for consideration herein, which were not raised or considered in synthetics. Take a case where two industries A and B come forward with proposals to manufacture rectified spirit. A says that it proposes to manufacture rectified spirit and then denature it immediately and sell it as industrial alcohol, while B says that it will manufacture rectified spirit and utilize it entirely for obtaining country liquor, arrack or by whatever other name it may be called, or for manufacturing Indian-made foreign liquors from out of it or to supply it to others for the said purpose. According to synthetics, A is under the exclusive control of the union, and only powers of the state are those as are enumerated in para 86, that is para 86 of synthetics, quoted above. But what about B? The rectified spirit manufactured by it is above meant only for potable purposes. Can it yet be called industrial alcohol? can it still be said that the state concerned has no power or authority to control and regulate industry B, and that the union alone will control and regulate it until the potable liquors are manufactured? The union is certainly not interested in nor concerned with the manufacture or process of manufacture of country liquor or IMFLs. Does the situation not leave a large enough room for abuse and misuse of rectified spirit? It should be remembered that, according to many states before us, bulk of the rectified spirit produced in their respective states is meant for and is utilized for obtaining or manufacturing potable liquors. Can it be said, even in such a situation, that the state should fold its hands and wait and watch till the potable stage is reached? Yet another and additional circumstance is this: it is not brought to our notice that any notified orders have been issued under 18G of the IDR Act regulating the sale, disposal, or use of rectified spirit for the purpose of obtaining or manufacturing potable liquors, which means that by virtue of entry 33 of list 3, the states do have the power to legislate on this field not occupied by any law made by the union. It is these and many other situations which have to be taken into consideration and provided for in the interests of law, public health, public revenue, and also the interests of proper delineation of the spheres of the union and states. The line of demarcation can and should be drawn at the stage of clearance stroke removal of the rectified spirit. This is what Mr. Dattar was also stressing on when I beg to do the same. Where the removal clearance for the industrial purposes, that is other than the manufacture of potable liquor, the levy of duties of excise and all other control shall be of the union. But where the removal clearance is for obtaining or manufacturing potable liquors, the levy of duties of excise and all other control shall be that of the states. This calls for a joint control and supervision to the process of manufacture of rectified spirit and its use and disposal. We proceed to elaborate. So far as industries engaged in manufacturing rectified spirit meant exclusively for supply to industries, that is, industries other than those engaged in obtaining or manufacture of potable liquors, whether after denaturing it or without denaturing it are concerned, they shall be under the total and exclusive control of the union and be governed by the IDR Act and the rules and the regulations made thereunder. In other words, where the entire rectified spirit is supplied for such industrial purposes, or to the extent it is so supplied as the case may be, the levy of excise duties and all other control, including establishment of industry, shall be that of the union. The power of the states in case of such an industry is only to see and ensure that rectified spirit, whether in the course of its manufacture or after its manufacture, is not diverted or misused for potable purposes. They can make necessary regulations requiring the industry to submit periodical statements of raw material and the finished product and are entitled to verify their correctness. For this purpose, the states will also be entitled to post their staff in the distilleries and levy reasonable regulatory fees to defray the cost of such staff as held by this court and so and so, so and so. So, whereas industries engage in the manufacture of rectified spirit exclusively for the purpose of obtaining or manufacturing potable liquors or supplying the same to the government or its nominees for the said purpose are concerned, they shall be under the total and exclusive control of the states in all respects and at all stages, including the establishment of the distillery. In other words, where the entire rectified spirit produce is supplied for potable purposes, or to the extent it is so supplied as the case may be, the levy of excise duties and all other control shall be that of the states. According to the state governments, most of the distilleries fall into this category. So, whereas industries engage in the manufacture of rectified spirit, both for the purpose of supplying it to industries other than industries engage in obtaining or manufacturing potable liquors or intoxicating liquors, and for obtaining or manufacturing or supplying it to government persons for obtaining or manufacturing potable liquors are concerned, the following is a position. The power to permit the establishment and regulation and functioning of the distillery is concerned, it shall be the exclusive domain of the union. But so far as the levy of excise duties is concerned, the duties on rectified spirit removed, cleared for supply to industries other than industries engaged in obtaining or manufacturing potable liquors shall be levied by the union, while the duties of excise on rectified spirit cleared, removed for the purpose of obtaining or manufacturing potable liquors shall be levied by the state government concerned. The disposal, that is clearance and removal of rectified spirit in the case of such an industry, shall be under the joint control of the union and the state concerned to ensure evasion of excise duties on
To
rectified.
ensure against evasion, I think.
Yes. No, my lords, when your lordships kindly come to
Just continue reading it. It's good.
yes, I'll read. It is obvious that in respect of these industries too,
Against evasion. There's a missing word there.
it is obvious that in respect of these industries too, the power of the states to take necessary steps to ensure against the misuse or diversion of rectified spirits meant for industrial purposes, that is supplied to industries other than those engaged in obtaining or manufacturing potable liquors to potable purposes, both during and after the manufacture of rectified spirit, continues unaffected. Any rectified spirit supplied, diverted, or utilized for potable purposes for obtaining or manufacturing potable liquors shall be supplied to and or utilize as the case may be, in accordance with the state excise enactment concerned and the rules and regulations made thereunder, if the state is so advised, it is equally competent to prohibit the use, diversion, or supply of rectified spirit for potable purposes. It is advisable, nay necessary, that the Union government makes necessary rules and regulations under the IDR Act, directing that no rectified spirit shall be supplied to industries, except after denaturing it to save those few industries, other than those industries which are engaged in obtaining or manufacturing potable liquors, where denatured spirit cannot be used for manufacturing purposes. So far as rectified spirit meant for being supplied to or utilized for potable purposes is concerned, it shall be under the exclusive control of the states from the moment it is cleared, removed for that purpose from the distillery, apart from other powers referred to above. The power to permit the establishment of any industry engaged in the manufacture of potable liquors, including IMFLs, beer, country liquor, and other intoxicating drinks, is exclusively vested in the states. The power to prohibit and to regulate the manufacture, production, sale, transport, or consumption of such intoxicating liquors is equally that of the states, as held in Magdal. The writ petition is disposed of the above. No, my lord, in the query which your lordships had put to me yesterday, my lord, I made a submission that entry 8 covers all varieties of liquor, all varieties of alcohol, except denatured spirit. My lord, I stand by that. But to the further query which your lordships had put, therefore, is the state completely giving up any kind of control over the rectified spirit or which is denatured spirit as such? My lord, in my respectful submission, what I submitted, my lord, or what I wanted to submit is that I don't propose to exercise any control over denatured spirit insofar as entry 8 is concerned. But that's not the same thing as saying that I may not do it, my lord, for the purpose of entry 33. And, my lord, because if it doesn't come under entry 8, then it would fall under entry 24, but it will be subject to entry 51. If it is declared as an industry, my lord, if it is not declared as an industry for public purposes, my lord, under entry 52 of list 1, then, my lord, state has complete control anyway on that. Suppose it is not scheduled to the IDR Act at all. State has complete control. But we are looking at a situation where fermentation industry is an item is scheduled to the IDR Act. And therefore, my lord, what happens? Therefore, my lord, I'll have to, the power exercised under entry 84 will still have to be subject to what is mentioned, my lord, in section entry 33. IDR Act is there. But there is a long line of judgments, my lord, which have already been placed before your lordships, including Tikaramji, and thereafter, my lord, finally ending with ITC Justice Umapal's judgment, that unless there is a notified order under section 18G of the IDR Act, there is no, my lord, legislative measure brought into place by the central government, even in relation to any one of the scheduled industries, which are scheduled to the IDR Act as such. Therefore, my lord, the field is open for the state government, my lord, even for regulatory measures. I am not saying for fiscal purposes, because it doesn't fall under entry 8. And therefore, my lord, I cannot do it. If you look at entry 51 of list 2 and entry 84 of list 1 as it stood prior to the 101st Amendment, my lord, anything other than alcohol for human consumption or liquor for human consumption, my lord, it cannot be taxed by the state. This is what is mentioned.
Therefore, the logical sequitur of your argument is that denatured spirit will fall outside the purview of entry 8.
Yes, yes.
By virtue of the fact that it falls outside entry 8, it must necessarily fall under entry 24.
Correct.
Where there's a declaration under entry 52.
Yes.
It will fall under entry 52. And therefore, that product ultimately is governed by entry 33.
Yes.
In case there's a notified order, then you have to follow the order.
Correct.
To be passed in a legislation under entry 52.
That's right.
Now, only one question. In fact,
yes.
Manoj, if I'm with my brother, just Manoj Mishra's permission, we were both discussing last evening. What happens in the case of an integrated unit? Because that's the point which Brother Manoj Mishra had raised when we were in conversation last evening.
My lord, with respect, my lord, it struck me also. My lord, that's, my lord, because what has been mentioned in Bihar distilleries also. And, my lord, the chart which Mr. Dattar had also provided. It starts out with a unit, my lord, which has to manufacture extra neutral alcohol. And then, my lord, we cannot, but it is not inconceivable that there could be a unit, my lord, which says 90% or 70% of it, I'll take it for use it for portable purposes, but 30% I'll use it for industrial purposes. What happens then? Slightly vexed question, my lord. I'm just with respect, my lord, I'm just suggesting one scenario, my lord. My lord, in my respectful submission, up to extra neutral alcohol, It is, my lord, within the control of the state. What happens, my lord, post production of extra neutral alcohol? That's a product. And therefore, my lord, extra neutral alcohol is also covered by entry 8. Production of extra neutral, there could be cases, my lord, where they produce only ENA. And then, my lord, sell it to other distilleries, my lord, which may blend it and then manufacture Indian-made foreign liquor. That's what happens in many cases also. There are very few units, my lord, which actually manufacture ENA and then also manufacture, my lord, the denatured spirit. Because it's only denatured spirit, my lord, which can be treated as industrial alcohol. That is why, my lord, there could be some reconsideration, my lord, which we respectfully urge that your lordships may do, insofar as synthetics and chemicals are concerned. But coming back to this scenario, in my respectful submission, till the production of ENA, the unit still comes under the control, my lord, of a state.
But if it's a unit, as Brother Mishra was suggesting yesterday, Manoj, if there's something further, Brother Manoj, something you can ask on that. Huh?
No,
Please,
there
please.
are occasions where alcohol is used for converting into a substance which is not non-alcoholic, like MEG. For example, there is a process for converting sugar into molasses. Molasses is fermented, alcohol is generated. Alcohol is then converted into MEG. MEG is a polyester raw material. Now that is no longer an alcohol, but it's not a case where 30% is diverted or 70%. It's a case where it is a complete conversion of the raw material. What would be the scenario in such a case?
My lord, in my respectful submission, till the production of, that is where, my lord, the question of clearance comes in. If the clearance is for the purpose of treating it as industrial alcohol, then probably the state would be out of bounds there.
Mr. Attorney and Mr. Solicitor, when you are responding, don't respond right now because since he is in the midst, this is an area because, ultimately our answer should not be very simplistic. We must be conscious of what the permutations and combinations are on the ground. So maybe, because your officers will be instruct you for the union would be very much more conversant with what the exact. So, just when you are taking instructions, just, because ultimately this will be of crucial revenue significance to both sides.
It would be.
This was not in our mind.
But both will have.
We'll take instructions from
Yeah.
the.
As well as
But this is not limited. But I was actually, because he's much
Mr.
more.
Datta, any, you'd like to share?
Lordship's question. If it's an integrated unit, now integrated meaning the ENA never comes out because when you say central excise duty, you have to decide what is your final product. When you get a license under Rule 44, you say, what is my final product? If my final product is MEG, or it could be isopropyl alcohol, whatever it is never meant to be. Then, my lord, it will come under my submission. It will be a fermentation industry other than portable alcohol. It will come under ND26 directly. Because if it's fermentation industry with portable alcohol, you're out of the amended 26. So you could have a situation where the raw material, what they call the substrate is still molasses. Molasses will be converted into alcohol, but that alcohol is never diverted for human consumption. Straight, it's an integrated process, start to finish. You put molasses here, you get MEG outside. It will be an industry based on fermentation. 26, that's my submission.
No, but I thought what fell from your lordships is something slightly different.
I think
Lordships were
lordship's
thinking about a
question
case where part of the alcohol goes into portable purposes and part of the
No, no.
ENA goes.
No, the whole of the alcohol goes for conversion into a final
No, no.
product.
The good test is, what is the final product of this unit? If the final product is MEG, then
But if it's a.
Suppose it is a dedicated industry
yes,
for producing MEG,
yes,
then it will have a different understanding.
yes.
Yes.
But suppose it is starting off as a, what is that, extra neutral alcohol producing, and then eventually subject to demand, let us say,
Yes.
you are in that industry, extra neutral alcohol, you are up till the state is till then in control. Thereafter, depending upon how, at the point of removal, what extent you are removing, then state and union control will come in. That's what I think Justice Jiban Reddy had said.
Yes, Lord, your lordship, the answer is, in your lordship's example, my final product will say ENA, extra neutral alcohol.
Your final product will say.
My license will say
Yeah.
extra neutral alcohol. I have to get permission from the state distillery.
Right.
But if
Then-
I'm going to make MEG or if I'm going to make alcohol-based final products, because there's a host of final products which can be based out of alcohol, then I will go for an excise license or now a GST license, and I will never come within the purview of the state law because I'm never making ENA at all. I'm never clearing ENA.
That time you are adding the denatured elements.
Yes, there my
etc.
final product is potable alcohol.
Correct.
That's why what they say is intoxicating liquor is intoxicating liquor. To the extent you denature it, it doesn't cease to be intoxicating. It becomes unfit for human consumption.
That is a little area
That's the area,
little
Lord,
area of
that-
divergence between you and Mr. Giri's.
Yes, Lord, I would
yes.
still stick to the submission,
Got
Lord,
it,
with
yeah.
respect.
Yes, yes.
Yes. Lord, para 3 of.
But only thing,
subpara-
Lord, we both say I'm under state control.
That's-
So we are denatured. Here I'm under state under entry 8. He's under state in entry 33.
33.
But your
Right.
lordship's answer is correct. If the center is notified, then under Mr. Giri's argument, denatured will come under central control,
Right.
under 18G.
Yes.
Lord, subpara 3 of para 23 of Bihar distilleries deals with this aspect. I think when your lordship said integrated, your lordships had in mind a case where up to the stage of production of extra neutral alcohol, Lord, there is no divergence. But after ENA comes into being, part of it is may not diverted for an industrial purpose, either by denaturing it or may not for whatever the process, it has to be denatured. It then becomes industrial alcohol. Justice Jeevan Reddy's judgment, my lord, also speaks about a case where without denaturing it, it is still treated as industrial alcohol because it is not meant for potable purposes at all. In my respectful submission, since ENA is also, my lord, alcohol, which would come under entry 8, it is not inconceivable, my lord, that the state may come out with a, my lord, like in, my lord, intermediate products could also be subject, my lord, to an excise duty or a levy. And therefore, ENA is an intermediate product and not the final product as such. ENA could be subjected to. But where the ENA goes into the manufacture of potable alcohol, I don't subject it to an excise duty at the stage of ENA. I'll probably reserve my right to do it after the final product comes out. But why should I lose out? Why should the state lose out if the control comes under entry 8 and it says production, manufacture? Manufacture is always not conceived of the final product. Production is of an intermediate stage. And if therefore extra neutral alcohol, even if it is 95% as mentioned in para 74 of synthetics and chemicals, is still a product which is covered by entry 8. I would not by lose my right, not even under entry 8, to tax it before it is cleared, my lord, for industrial purposes. Therefore, my lord, this is my respectful submission. To that extent, subpara 3 or the paragraph 23 may be, my lord, modified by your, in Bihar distilleries also should be modified by your lordships. It's my respectful submission. My lord, just one more aspect, my lord, and I'll complete it. In synthetics and chemicals, my lord, and why? Take synthetics. This may move on synthetics and chemicals. Synthetics and chemicals, my lord. I'll complete my submissions. Synthetics and chemicals is 1991 SEC, page 1. 1990, page 1 SEC. Give the citation for synthetics and chemicals. 109. My lord, it's in volume 5, page 9, PDF page 9. My lord, lordships may come to paragraph 74 at PDF page 54. I don't want paragraph 41. I'm going to paragraph 74. My lord, the objectionable portion, my lord, if I may say so with respect.
Page 50.
PDF page 54, paragraph 74. My lord's got it. Your ladyship has it?
Yes.
It has to be borne in mind that by common standards, ethyl alcohol, which is 95%, is an industrial alcohol. This, my lord, we would respectfully submit. We would most respectfully urge requires reconsideration. Why, Lord? Why should it be question which I ask unto myself is, why should it be treated as an industrial alcohol? It's extra neutral alcohol with a higher strength. It can be used for human consumption. Of course, my lord, by tempering it with water or by any other substance as such. But there is no question of, my lord, it becoming irretrievably unfit for human consumption. That happens only on denaturing. The petitioners and the appellants were manufacturing ethyl alcohol, also known as rectified spirit, fair enough, which is an industrial alcohol. My lord, that doesn't go as a sequit. ISI specification has divided ethyl alcohol into several kinds of alcohol. Beverage and industrial alcohols are clearly and differently treated. Rectified spirit for industrial purposes is defined as spirit purified by distillation having a strength not less than 95% of volume by ethyl alcohol. Dictionaries and technical books would show that rectified spirit is an industrial alcohol and is not portable as such. But then where is the reference, my lord, to the legislations which were existing from 1880 onwards? It appears therefore that industrial alcohol, which is ethyl alcohol, by itself is not only non-portable but is highly toxic. The range of spirits of portable alcohol is from country spirit to whiskey, and ethyl alcohol content varies between 19 to 43%. These standards are according to the ISA specifications. In other words, ethyl alcohol 95% is not alcoholic liquor for human consumption, but can be used as raw material input after processing and substantial dilution in the production of whiskey, gin, country liquor, etc. Entry 8 relates to production also. My lord, why should ethyl alcohol at 95%, which is one of the raw materials, or which is used as a base for preparing different varieties of Indian-made foreign liquor or country liquor for that matter, where only there is a dilution by addition of water, why should it fall outside the purview of alcoholic liquor for human consumption as mentioned in entry 8? But can be used as a raw material input after processing and substantial dilution in the production of whiskey, gin, country liquor, etc. In many decisions, it was held that rectified spirit is not alcohol fit for human consumption. Reference may be made in this connection to so and so, so and so. In this connection, it is important to bear in mind the actual provision of entry 8 of list 2. Entry 8 of list 2 cannot support a tax. The above entry contains the word intoxicating liquor. The meaning of the expression intoxicating liquor has been rightly interpreted by the Bombay High Court in Balsara. The decision of the Bombay High Court is reported in so and so. In that light, perhaps, the observation of Justice Fazal Ali in Balsara's case requires reconsideration. It appears that in the light of the new experience and development, it is necessary to state that intoxicating liquor must mean liquor which is consumable by human being as it is and as such. When the word liquor was used by Justice Fazal Ali, they did not have the awareness of full use of alcohol as industrial alcohol. The point is not that. The boot is on the other foot. Can it be used as portable liquor? It is true that alcohol was used for industrial purposes then also, but the full potentiality of that user was not then comprehended or understood. With the passage of time, meanings do not change, but new experiences give new color to the meaning. In Harshankar's case, A bench of 5 judges have surveyed the previous authorities. That case dealt with the auction of the right to sell portable liquor. The position laid down in that case was that the state had the exclusive privilege or right of manufacturing and selling liquor, and it had the power to hold public auctions for granting the right or privilege to sell liquor, and that traditionally intoxicating liquors were the subject matters of state monopoly, and that there was no fundamental right in a citizen to carry on trade or business in liquor. All the authorities from Mukherjee Barucha to Harshankar dealt with the problems or disputes arising in connection with the sale, auction, licensing or use of portable liquor. Now, my lord, in para 77, Article 47 of the Constitution imposes upon the state the duty to endeavor to bring about a prohibition of the consumption except for medicinal purpose of intoxicating drinks and products which are injurious to health. If the meaning of the expression intoxicating liquor is taken in the wide sense adopted in Balsara's case, it would lead to an anomalous result. Does Article 47 oblige the state to prohibit even such industries as are licensed under the IDR Act, but which manufacture industrial alcohol? This was never intended by the above judgments of the Constitution. It appears to us that the decision in Synthetics and Chemicals Limited, the first one, was not correct on this aspect. Then, my lords, please come to paragraph 81, the conclusion, 81 onwards, lords. It is not necessary for us here to say anything on the impose on portable alcohol as commonly understood. These are justified by the list of our legislature practice in this country. See the observations of Justice Hidayatullah as Chief Justice then was in Guruswamy. In that view of the matter, it appears to us that the relevant provisions of the UP Act, AP Act, Tamil Nadu Act, Bombay Prohibition Act, as mentioned herein before, are unconstitutional insofar as these purport to levy a tax or charge imposed upon industrial alcohol, namely alcohol used and usable for industrial purposes. This is where the shoe pinches for us. In our respectful submission, this would be correct. Para 82 could be affirmed if instead of industrial alcohol, it is used as denatured spirit. But if, since in para 74, the lordships have synonymously used industrial alcohol and rectified spirit would be 95% ENA. My lord, this would be incorrect, my lord, in my most humble, respectful submission.
While arriving at this conclusion in paragraph 82,
Minutes.
there must have been a discussion on the content of entry 8, list 2,
There was
on the scope and ambit of that.
para 41, my lord, contains that.
It's at the bottom of 74.
Para 70.
At the bottom.
That I have read. I have read para 74. 67. Yes, my lord. Could your lordships have a look at para 41 and then 67? There is a reference to para 41. There is a reference to it in para 41. That is a PDF page 37.
So according to in para 82, instead of industrial alcohol, if you were to read the word denatured spirit,
That's it.
that would solve
That would
the problem.
suffice. That would suffice. My lord, your ladyship was asking about the
Which
discussion.
para were you saying, Mr. Giri? 44, is it?
41. 41. 41 at PDF page 37. Lord, the question was formulated, but thereafter, my lord, I think it went into. The only question which has to be determined is whether intoxicating liquor in entry 8 in list 2 is confined to portable liquor or includes all liquors. According to the Union of India, in view of the difference of language in entry 8 and entry 51 of list 2, it is reasonably possible to take the view that intoxicating liquors include both liquors. It was submitted by the Union of India that there are no grounds for overruling Balsara, decided in 51 after 38 years, particularly when it has been followed and applied in later decisions. In that case, it upheld the power of the states to completely prohibit, manufacture, sell, etc. potable liquor. It struck down the provisions of the Bombay Act insofar as it imposed restrictions on medicinal and toilet preparations as violative of 19(1)(f) of the Constitution. It is stated that this decision had proceeded on the basis that there could not be a complete prohibition in regard to medicinal preparations containing alcohol. Hence, it was submitted that so far as alcohol not fit for human consumption is concerned, it cannot be held that trade in such an article cannot be considered to be a noxious trade. It will be a noxious trade only when it is produced or manufactured for purposes of human consumption. It is submitted that Indian Mica and Micanite Industries versus State of Bihar. This court was dealing with denatured spirit and had held that Bihar Odisha Excise Act, insofar as it related to denatured spirit, was regulating trade and business in public interest, and that entry 8 of list 2 comprehends all liquors containing alcohol. The state's privilege to completely prohibit or farm out liquor containing alcohol for human consumption does not comprehend, according to the Union of India, a similar right of a state with regard to other intoxicating liquids containing alcohol. According to the Union of India, to so prohibit or collect fee for farming out would be unconstitutional under 19(1)(g) of the Constitution, on the same principle on which the provisions of the Bombay Act was struck down in Balsara. It was further stated on behalf of the Union of India that Parliament has legislative competence with regard to power alcohol, providing for levy of central excise duty. See the central excise, but the discussion remains unconclusive in 41. Mr. Dwivedi says 67, 74 I have already read. 74 I have already read out to your options. Well, in my respectful submission, alcohol fit for in entry 8. Yes, intoxicating liquor would take in, my lord, everything other than denatured spirit in entry 8. And therefore, it would take an extra neutral alcohol also, rectified spirit.
Yes.
My lord, the rest of the areas have been covered.
Thank you, Mr. Giri. Thank you.
Grateful to your options. Deeply grateful.